annulment and enforcement of foreign arbitral awards, which is excellent because we already have a backdrop of arbitration early. As many of us know, that have taken classes like security transaction and bankruptcy, we study, in first year law, and a lot of it's obtaining judgments. But when the rubber really meets the road, and someone has to enforce the judgment, sometimes it's hard to get their hands on money. Domestically, we have tools for collection like levy and garnishment, foreclosure that tend to address these things. But we can see how when it comes to international disputes, there's massive coordination problems that have arisen over the years, particularly relating to arbitration and enforcing arbitral awards that have been entered in one nation and attempted to be enforced in another. So over the years, we've developed some of these global legal rules via treaty to solve these problems. And I want to talk a little bit about the New York Convention, which was a collective effort to try and establish conformity in the enforcement of foreign arbitral awards. Specifically, Article 5 of this convention provides that courts may refuse, well actually it also relates more to annulment. It provides when an arbitral award is entered in a nation and then is contested and eventually annulled by that nation, or by the courts of that nation. So if a party wants to then go and try and get it enforced in another nation, Article 5, what it does is grants discretion to the courts in the enforcement nation to be able to enforce that arbitral award anyways. And the language of it says they may refuse to enforce an arbitration award on certain grounds. Nullification in the country where the seat of arbitration is located is one ground to refuse enforcement, but it doesn't require it. Other sections of the New York Convention require it. There they say shall refuse, but this one does not. So we're going to examine that a little bit in this rule and how it's a kind of a soft line rule and whether discretion is a good thing, whether it's a bad thing, and maybe possible alternative solutions here. But I want to explain, give a backdrop, kind of see how this plays out in the PEMEX Exploración case, which is a very controversial recent 2013 decision that kind of changed a lot. And what it was is PEMEX Exploración was a Mexican sovereign entity. Basically, it was which was contracting with an American corporation and a subsidiary of the American corporation in Mexico. And they had an arbitration agreement, which also provided, the agreement provided things such as the ability of PEMEX to administratively rescind the contract. Eventually things go sour. PEMEX Exploración administratively rescinds the contract. What happens is COMISA, the other party, which is the American corporation, wants to arbitrate this, but the contract also said it was governed by Mexican law, and the Mexican corporation, PEMEX, tries to say, well, we administratively rescinded it, that's not subject to arbitration. And so this there's 20 years of procedure involved in this case. I can't even begin to go into it, but eventually what happens is, it goes up the arbitration proceedings go on anyways. PEMEX Exploración gets hit with a $400 million arbitration award, and COMISA tries to enforce that in the United States, in the Southern District of New York. While this award is eventually annulled in Mexico, the Mexicans, it goes it's before the Mexican Supreme Court at one point. It's eventually annulled on all sorts of grounds. Basically, they're saying that an administrative rescission is an act of authority not subject to arbitration. So what happens is the Southern District of New York decides to enforce the award anyways. They're saying, well, we have discretion to enforce this award under the New York Convention, Article 5. So, in that case, it essentially there was a whole analysis, but they really did a substantive review of what the Mexican courts did. So it's up on appeal right now, but I want to discuss some ramifications and potential problems with this, and really how we've seen the discretion here in Article 5 play out. So the purpose behind this rule that grants discretion to courts was a localistic protectionism that we were seeing around nations where during nullification proceedings, many courts would protect or be favorable, biased towards potentially a sovereign entity that was involved of their own respective nation. So this may refuse clause was trying to curb some of those concerns by allowing courts to then go enforce it anyways if they see some of these protections. What happens here is, though, the problem is we still have localistic protectionism, but not at the nullification level, but at the enforcement level. And now, whether or not the court here got it right or wrong in PEMEX, the potential for bias when a court is going to enforce an arbitration award is just as prevalent as when it's attempting to be nullified in the nation where the seat is located. So, for example, this was an American corporation coming to the American courts attempting to enforce this award that they thought they were wrong, and the American courts have done it. So that, and we also have massive reciprocity concerns when these courts are substantively going in and reviewing what other courts have done in other nations. So, you know, that there could be problems there. On a private negotiation level, we're going to see a change in bargaining power if this becomes more widespread, because, you know, often the seat of arbitration is bargained for, which has to do with annulment as well. And if there's a disparity created when other nations can disregard the host nation's annulment power, that's going to change the bargaining power at that level. So some of these issues, and we don't really know the ramifications yet, but I want to just discuss a couple possible solutions. As everyone knows, if you know anything about international arbitration, there's very, very massive freedom of contract here. Contemplating this jurisprudence at the very basic level, when we're talking about, you know, thinking forward, parties negotiating arbitration agreements are in a sequential game. You have to look forward to the possibilities of what the other side is going to do. Contemplating this jurisprudence here and thinking forward to, you know, if we look at the PEMEX case, the possibility of administrative rescission, if they would have simply crafted a clause in the arbitration agreement saying, we're going to arbitrate this, the Mexican courts would really be left with no discretion to then go and nullify it. And I mean, and they don't even have to govern, even just because the seat of arbitration is located in one country doesn't mean they have to be governed by the laws of that nation. So there's a lot of flexibility here, and if we can have people during negotiations look forward, I think this could be largely solved. You know, additionally, we have a difference in bargaining power here, and if we limit the PEMEX holding to a very narrow scope, then I think it should all be worked out in bargaining power. For example, if one party can't obtain these certain provisions in the arbitration agreement, that could be a result of lack of bargaining power, and maybe it was a risk that the American corporation was willing to take when entering into these negotiations with a Mexican sovereign entity. The fact that they may not be able to arbitrate at something like an administrative rescission. You know, however, I think that PEMEX does have its place and this discretion does have its place in very limited scenarios. For example, if the Mexican court, you know, despite arbitration language providing, you know, that